Welcome, everybody. Good afternoon. I'm David Blight, the director of the Gilder Lehrman Center for the Study of Slavery and Abolition. This event is co-sponsored by our colleagues at the Shell Center for Human Rights at the law school, and Jim Silkett's director just walked in. I don't know. There he is. Thank you, Jim, for helping out with this. And by the Yale chapter of the American Constitution Society, which is an organization of law students and others. Alda, are you here? We had a lot of emails with you. I'm not sure. Okay. Anyway, thank you to both. We conceived this months ago as a chance to discuss a major issue in this election, a few days before the election. And you never know, but of course voter suppression is now in the news, well, never quite on page one, but it's in the news almost every day, which is one of the things I'm going to get this panel to discuss, why it isn't more at the top of agendas. I will introduce everybody here in just a moment, and each is going to get a 5-minute opening to give us context, historical and current, with particular focus on North Carolina, which is where Isela is from. But very briefly, I want to simply say first that in thinking about where to begin today, in fact, we were just over here musing about where do you begin this story? And we ended up at the founding of the United States. Alien and Sedition Acts, the early exclusion laws in northern states. This is hardly a southern story. I don't know. We didn't even get to the 15th Amendment as a place to start. But we're going to get out of the 19th century fairly soon here and right up to the present, I promise. But I wanted to point out, and some of you may or may not remember this, I wrote a piece in the New York Times just before the 2012 election. And of course, we don't want to be partisan here, but I don't know how you talk about this issue and not be. So I pointed out in 2012 that one of the very first things Frederick Douglass did when he escaped from slavery, and he was living in New Bedford, Massachusetts, is he walked 3 blocks down the street to the city hall and he registered to vote. He registered to vote in Massachusetts in 1840 and again in 1841. He probably voted for William Henry Harrison in the log cabin campaign of 1840, although I don't know that for sure. But we need to think of that context. This was a man at that point who was in every conceivable way an illegal immigrant. He was a fugitive slave. He was living under his 4th assumed name. He was committing colossal voter fraud. So, and the only documentation he could have conceivably shown, if he had to, an ID, was his fake Seamen's Protection Papers, which is one of the means by which he escaped from slavery. He had borrowed a black Seamen's Protection Papers, which had the American Eagle at the top. He was living under that assumed name first. Then he had a 1-sentence little letter that declared he had been married to Anna Murray by the former fugitive slave James Pennington. And even in that document, they were called Mr. and Mrs. Johnson, which was one of his assumed names. So I simply suggested in 2012 that rather than continuing to try to suppress the votes of African Americans, what the Republican Party ought to do is create what could be called nationally the Frederick Douglass voter voucher, by which they would take the exact amount that was paid for Douglass's freedom in 1847 when his British friends bought his freedom, which was 150 pounds and approximately $711. And I just suggested that rather than pass all of these hundreds of voter restriction laws, that they just pay all the black people in the United States $711 apiece. Just pay them not to vote. See if they take it. Why not? And we wouldn't have to go through all these laws. Just pay them off. You know, that'd be within their sort of ideological framework, I would think. I had a lot of responses to that op-ed, and not all of them favorable, to say the least. But, you know, if you needed to know, you know that Frederick Douglass committed voter fraud, sort of, under 4 different names. All right. We're here in part because Ari Berman wrote this book called Give Us the Ballot. And we're going to hear about it in a minute, and we'll hear about it some more when we get to have conversations. I want to introduce everybody now as quickly as I can with these massive bios they all have. Ari Berman is a senior writer at The Nation magazine. He's written for all kinds of other publications. He's written many pieces for The Nation on voting rights and voter suppression over the years, which some of you surely know, the New York Times, Rolling Stone, The Atlantic, Politico, The Guardian, and many others. He's been a commentator in numerous TV programs on NPR. He's the author of 2 important books. The first was Herding Donkeys, The Fight to Rebuild the Democratic Party and Reshape American Politics, which was in 2010. And the book most relevant to our discussion here that just came out last year, entitled Give Us the Ballot, The Modern Struggle for Voting Rights in America. That book is on sale at, what is it, the Barnes & Noble, downtown, or down on Broadway. Isela Gutierrez comes to us from North Carolina via many other places. She has a BA from Scripps College in California, a Master of Social Work from UNC Chapel Hill. She started her social justice work, I believe, in Seattle with the ACLU back in the middle of the 1990s. She has worked for organizations in Austin, Texas, about prison reform, among other issues. She has worked for a voter engagement organization in Boston for a year or 2, and she's now been in North Carolina for several years, working in various kinds of organizations about racial justice, but particularly in the organization called Democracy North Carolina, which has been an advocacy group in that state now for many years, and she's going to tell us about it, that has worked in a nonpartisan way, it says, to fight for voting rights and other kinds of rights, and especially in recent years over the NAACP versus McCrory case, the famous case in North Carolina. And North Carolina has been a kind of ground zero of this problem of voting rights and voter suppression. And Isela, we're very glad you took the flight up here in what must be a crazy busy week in North Carolina. Ken Mack, just to my left, is the Lawrence Beall Professor of Law and History at Harvard. He's a co-faculty leader of the Harvard Law School's program on law and history. Ken is a historian and a law professor. I always like to point that out when we have a law professor person around, which we have a lot of. He's run a program most recently at the Charles Warren Center at Harvard, which is the Center for American History, on the history of capitalism. He's the author in 2012 of Representing the Race, the Creation of the Civil Rights Lawyer. Terrific book, I strongly recommend. And he's written all sorts of law review articles, et cetera, et cetera. He's an expert on the history of civil rights, both before 1965 and post-65. He's co-editing a book now on civil rights since the 70s. And he and I were on a panel just recently in Maine, I think it was June 1st, on the 14th Amendment. It was great fun. It was just Ken and I kind of going at it about the we didn't disagree on anything, but we kept trying to find something to disagree on. But there's no better audience, except this one, of course, than a public library audience, you know, run by one of those humanities councils. We had quite an audience that night. And finally, Bev Gage, who's my colleague in the history department. Bev teaches American political history, particularly in the 20th century. She's probably getting tired of being on panels about this election. This panel's not about this election. Well, at least not for a few minutes, anyway. Bev is the author first of the book, The Day Wall Street Exploded, which is about the famous, or she made it famous, Wall Street bombing in the 1920s, which I think is being made into a PBS documentary. She's currently working on a major biography of J. Edgar Hoover. That could change your point of view and ruin your wits, but Bev can do it. The book's going to be called G-Man, J. Edgar Hoover in the American Century, done in a couple of years. You won't want to miss it. She's been a commentator on PBS, lots of other places. She's written a lot for popular journalism. She's a terrific writer, a public intellectual, public historian in the fullest sense. And I asked her to be on this panel because she's so good at politics. Of course, she just reminded me today, what do you want me to do? Provide 200 years of context in 5 minutes? And I said, yes, that's what I want you to do. Anyway, Bev is going to be down there to clean up for everything that isn't said by the first three speakers. Ari, you get the first 5 minutes. If you don't cover all the questions I have about your book, we'll get you later. But you're up first, then Estella, then Ken, then Bev. Thank you.
Well, thank you so much for having me. Can everyone hear me? It's great to be on this esteemed panel. And also, I love speaking at colleges that I know that I wouldn't have gotten into as an undergrad. So now I have honorary speaking degrees from places like Yale and Harvard, which is
That's what I say every day when I teach here.
So I just want to talk a little bit about the history behind the Voting Rights Act and then what's happening in this election. So my book is called Give Us the Ballot because that was the title of the first major speech that Martin Luther King gave about voting rights in 1957. He, at that point, was just 28 years old, and the gathering was called the Prayer Pilgrimage for Freedom. It took place at the Lincoln Memorial, and in many ways it was the precursor to the March on Washington that happened 6 years later in 1963. And the occasion for the Prayer Pilgrimage for Freedom was the 3rd anniversary of the Brown versus Board of Education decision that desegregated public schools. But 3 years after the Brown decision, no schools in the South had desegregated. And King was asking the question, why? How could the Supreme Court come up with this landmark case, and then all of the sudden states just ignored it? And what King was saying in his speech, Give Us the Ballot, was the reason why the South wasn't moving on school integration or any other issues was because the South was still controlled by white Southern segregationists who had no interest in doing anything on civil rights or anything else, and because there was so much voter suppression in the South, nothing would change. So King really believed that the ballot was the key to changing the entire landscape, so that people could not just marry who they wanted, or go to school where they wanted, or eat where they wanted, but so they could have real political power. And this speech in 1957 culminated really in an 8-year effort that led to the passage of the Voting Rights Act in 1965, the country's most important civil rights law, which is where my book, Give Us the Ballot, begins. It's also true that we're witnessing a 50-year effort to try to roll back the Voting Rights Act and to try to roll back the gains of the 1960s civil rights movement. And Beverly, I'm sure you'll talk about this, but in the same way that Reconstruction led to a redemption effort to try to redeem the white South, I think that the Voting Rights Act and more recently the election of the first black president has led to a new redemption effort to try to roll back the gains that we're making. So I began covering the issue of voting rights after the 2010 election. And what happened then was a bunch of states flipped from blue to red or became a whole lot redder. And we began to see a wave of new attempts to make it harder to vote. That from 2011 to 2012, there were 180 new voting restrictions introduced in 41 states. And half the states in the country changed their election laws to make it harder to vote. For example, by requiring strict forms of ID that you never needed before in any previous election, or cutting back on the amount of time that people had to vote, or making it harder to register to vote. And what was so interesting is this wasn't just happening in the South, wasn't just happening in Alabama and Mississippi. It was happening in places like Wisconsin and Pennsylvania that had a very different history. And then in June of 2013, the Supreme Court gutted the Voting Rights Act and ruled that those states with the longest history of discrimination no longer had to approve their voting changes with the federal government, and that really was basically a steroid for existing voter suppression efforts. So right now where we are is we're 5 days away, Lord help us, from the first presidential election in 50 years without the full protections of the Voting Rights Act. And 14 states, including some very important battlegrounds, like Wisconsin and Ohio and Virginia, have new voting restrictions in effect for the first time. Some of these laws have been blocked. Isella can talk about that in North Carolina, but lots of things have not been blocked. And so we're in a situation where millions of people are going to show up. They're already showing up in early voting, or they're going to show up on election day, and they're going to face a situation where it's tougher to vote in this election than it was the last time they cast a ballot. And I just want to tell one story about how this is impacting voters. I've been doing a lot of reporting in Wisconsin, which is one of the states that has a strict voter ID law. And in that state, 300,000 registered voters don't have strict forms of government-issued ID. That's 9% of the electorate. And I wrote about a guy by the name of Eddie Lee Holloway Jr., who was a 58-year-old African-American man who moved from Chicago to Milwaukee and had voted all his life in Illinois without problems. But when he moved to Milwaukee, he didn't have a Wisconsin photo ID that he needed to vote. So he went to the DMV in Milwaukee, and he brought his Illinois state ID, his Social Security card, and his birth certificate. But he was not given an ID for voting because the name on his birth certificate said Eddie Jr. Holloway instead of Eddie Lee Holloway Jr. Same first name, same last name, but because of a clerical error, different middle name, they wouldn't give him an ID for voting. Instead, he had to go down to the Vital Records office in Milwaukee and amend his birth certificate. He went down to the Vital Records office in Milwaukee. He said, "How much will it cost to amend my birth certificate?" They said between $400 and $600. So he bought a bus ticket. He went to Illinois, where he was from. He went to the state capitol in Springfield and said, "I want to amend my birth certificate." They said he needed to bring his high school and his vaccination records to do that. This is not a joke. He told this story under oath in a deposition. He then went to Decatur, his hometown, and got his high school records. He went back to the state capitol in Springfield. They said he needed to bring his full Social Security statement, which he didn't have. So he went back to Wisconsin. He got his documents in order, and he contacted Vital Records in Illinois, and he said, "Can I fax or email these to you?" And they said, "No, you have to come back in person and do this." And at that point, he gave up. This one man, Eddie Lee Holloway Jr., had been voting his entire life, made 7 trips to different public agencies, brought 3 different forms of ID with him to the DMV, spent over $200 of his own money, and can't vote in Wisconsin in 2016. And to me, this is the tragedy of this election. There's been so much talk about what the polls say, who are people going to vote for? But I've been asking an entirely different question, which is, will everyone who wants to vote be able to cast a ballot? I'm not concerned about people voting illegally. Frederick Douglass aside, that is a very small problem in American elections. I am concerned about people that have been voting their entire lives who are suddenly being disenfranchised for no good reason, because that's how one party believes it's going to recapture the White House and going to keep their grip on all of these states. So I'm glad we're having this conversation. I think this is an absolutely urgent problem in our democracy.
Thank you. Stella.
Hello. So it is 4 days before the election. I'll talk a little bit about the field program that we're running at Democracy North Carolina later, but I just ask your patience. I'm also the mother of a 9-month-old, my first child. So this is a big year for me, and I'll get better in the Q&A, I promise. But so Democracy North Carolina is a nonpartisan organization. We use organizing, research, and advocacy to do our work. We have field organizers across the state who assist us in engaging local communities. Before 2013 and the passage of what we call the monster voter suppression law, North Carolina had a sort of the Cadillac or maybe the Lexus or the BMW of voting systems. We had public campaign finance for judges and our Council of State. We had same-day registration during early voting. We had 17 full days of early voting. We had pre-registration for 16 and 17-year-olds. Any sort of reform that an elections expert might tell you would help people vote, North Carolina had it prior to 2013. And those reforms helped Black voters vote at rates equivalent to white voters in 2008, the first time that it happened. Same-day registration was passed in 2007, and it allowed 103,000 people to vote in 2008. We have very close races in North Carolina. As an example, in 2008, President Obama won the state by 14,000 votes. So you can see the impact that same-day registration and those other reforms had on the political landscape in North Carolina. So, but of course, North Carolina also has this other history, this history of voter suppression, this history of disenfranchising African American voters. As a result of that history, we were covered under Section 5 of the Voting Rights Act. 40 of our 100 counties were required to pre-clear any election changes before they made them. In 2013, in August of 2013, a month after the Shelby decision, which gutted Section 5 of the Voting Rights Act, North Carolina lawmakers, which had in our state house had recently turned from blue to red in the 2010 election, and it stayed red in 2012, and our governor or state house also went red. So shortly after the passage of Shelby, a massive omnibus bill was introduced. The monster voter suppression law is what we fondly call it in North Carolina. And it rolled back all of these provisions, public campaign finance provisions, disclosure provisions, in addition to eliminating all of these methods of voting, same-day registration, out-of-precinct voting on election day, pre-registration, and that first week of early voting. And I can tell you more about why these various methods of voting were important, but I'm going to try to keep it to 5 minutes and concise. So this massive sea change in our electoral structure happened after Shelby, after the elimination of preclearance. And in fact, one of our Senate leaders was very clear that they waited until the Shelby decision. You know, they knew Shelby was in the courts. They waited until the decision came down to push this law forward because they knew they could escape scrutiny from the federal government. So the law passes, and we have this major shift in our elections. 2014 was the first year we didn't have photo ID. Oh, and of course photo ID. I always forget photo ID. Was supposed to go into effect in 2016. So in 2014 is our first cycle that we have this everything except for photo ID is in place in terms of restrictions. We estimate we did a major education push that year. Everyone's focus has been on photo ID. What we wanted to let people know was about what effect it would have on them when they went to go vote for the first time. Because for these last two presidential cycles in 2008 and in 2012, people had been able to just show up and vote, more or less. Wherever they went, out of precinct in their county, they had moved to a new county recently, they could vote. That was the experience of most voters in North Carolina. In 2014, it changed. So we did massive voter education and organizing that year. And then for both the primary of that year and the general, we launched a statewide poll monitoring effort because we wanted to see what was happening with the implementation of these voting laws. We expected voters to be disenfranchised, but we wanted to actually see how it all went down and what poll workers were doing, how the changes in the law might have affected the way that poll workers were treating voters. So from that research, we gathered lots of stories. We worked closely with the legal teams to make sure that people who were disenfranchised, their stories made it into the case. But we also estimated from that about 30,000 voters were disenfranchised. And again, it wasn't a huge turnout cycle. The midterms never are. But we have such close races in North Carolina that those 30,000 votes matter. And of course, you know, philosophically, every vote matters, right? So we and all of our colleagues work to gather this information and show the negative impacts that the law is having on on voters in our state, and particularly Black voters. Ultimately, all of this effort culminates in a decision on July 29th of this year by the Fourth Circuit, which finds that the voter suppression law is unconstitutional and illegal in its suppression of black votes. The justification that lawmakers gave was, of course, voter fraud. It's rampant. We need photo ID to stop the rampant in-person voter fraud. But what the Fourth Circuit found was that actually this law targeted black voters with surgical precision. And when pressed in the court case, what Republican lawmakers said about their logic was that in fact they were engaging in voter suppression. They admitted it, but it was for political reasons, not for racial reasons. And so wasn't that okay? Well, in North Carolina, black voters are Democrats. It's an extremely racially polarized state when it comes to voting. And so what the Fourth Circuit said was, it's actually not okay, even if your justification is political, if it ends up with the impact of disenfranchising and suppressing the black vote, it's not okay. But in 2016, prior to that decision, we had already had our primary, our presidential primary, with photo ID, okay? And the state had been doing voter education for 2 years about photo ID. You need photo ID to vote, you're gonna need photo ID to vote. And so now, there was a whole lot of other stuff in between. But now we're in the tail end of our early voting cycle, and voters are able to vote by and large because they have same-day registration in place and out-of-precinct voting. They're limited, turnout has been limited in some areas because of other administrative wrangling around early voting sites and locations. And there is still some confusion about photo ID, most notably among poll workers, who you'd like to think would know the rules. We're seeing some isolated incidents of voter intimidation. We'll be launching another major election protection effort. We will be fielding 1,000 lay monitors, over 200 lawyers, and we're running the election protection hotline. So we are in the middle of it, in the thick of it, in the thick of laws that are intricate, the legal changes that are intricate and dynamic. One cycle they're here, one cycle they're there, and doing our best to educate voters and to try to keep an eye on all the various administrative bodies, from the state to the county level to local poll workers, to see how, in fact, the law is being implemented and how it's affecting voters.
Thank you. We'll come back to all of that. Ken.
Okay, so I'm going to try to be brief, although I'm a law professor, so this is a difficult thing. I'm going to start with I'm going to start by taking note of a recent opinion by the Sixth Circuit Court of Appeals, the federal appellate court that governs the Midwest. Thanks. I'm going to start by taking note of a recent opinion by the Sixth Circuit Court of Appeals, which is the federal court that governs the Midwest. And it involved a voting rights case that challenged 2 Ohio statutes that placed restrictions on absentee and provisional ballots and restricted the assistance that poll workers could provide to people who were trying to vote. So Ohio had certain voting laws in place. It changed its voting laws and added these particular restrictions. And the question was whether or not this change violated the Voting Rights Act. Majority of the Sixth Circuit said no and upheld the restrictions as not placing an undue burden on minority voters. But what's really noteworthy about the case is the dissent. The dissent was written by a black judge, a guy named Damon Keith, who's an old veteran of the civil rights movement. And what's noteworthy about what Judge Keith did is he began his dissent by appending to his opinion photos of 36 people who had been killed during the civil rights movement for what he said were advocating in the context of voting rights advocacy. Right after the photos, he has a short paragraph noting that in 2008, Barack Obama was elected as the first African-American president. So this is what the federal judge does in dissenting from this opinion. Judge Keith noted, quote, he said, quote, "It is imperative that we assess the efforts to undermine the right to vote as an historical operative that did not begin with the majority's opinion and unfortunately will not end with it." So what's going on? Judge Keith and the majority, they're kind of in different worlds, right? The majority says, well, you know, we've got these sort of changes in the voting laws, and Judge Keith is writing an opinion with 36 photos of murdered black and white people to it. Keith is invoking history, and he's invoking a history, I think, that the majority on his panel doesn't want to invoke. So what I'd like to do is just sort of like, I hope I can do this in 4 or 5 minutes. Try to answer the question, well, what did Judge Keith mean? Why does he see the stakes behind these Ohio voting restrictions in such stark terms? Well, as we were saying at the beginning, you could start, if you were going to look at this historically, you could start, way, way back. So I'm not going to start way, way back because I only have 4 minutes. I'm going to start sort of way back with what we might call the founding period for minority voting rights. Voting, as most of you know, in the United States is a local institution. It's controlled locally. This is why we fight in North Carolina, in Texas, in North Dakota, in Ohio, over who can vote for Congress and the President of the United States. The federal government does not control local voting procedures. In fact, that division of responsibilities is written into the United States Constitution, which explicitly says that state governments have jurisdiction over voting for members of Congress. Although Congress, of course, can act in the field, and Congress has, including passing statutes like the Voting Rights Act. But voting is local in the United States. And the thing that changed voting from local to something in which the federal government had a role was the first efforts to enfranchise black voters in the South in the aftermath of the Civil War. What happened? Well, Congress passed a couple of statutes. There is something called the 15th Amendment, which we all know about, but there are also these statutes. There's a thing called the Enforcement Act of 1870 and the Ku Klux Klan Act, both of which gave the federal government, for the first time, jurisdiction over what had previously been local voting procedures. These are this era's versions of the Voting Rights Act of 1965, right? So they're kind of doing a similar kind of thing a century earlier. Well, why did Congress do this? Well, because in the post-war South, voting was polarized. Race and political affiliation had a very strong correlation. Freed slaves and whites who were willing to make common cause with them were Republicans. Unreconstructed white Southerners were Democrats. And when that was true, there was a political impetus. I might argue there's always a political impetus when race or ethnicity match with political affiliation, and when voting is polarized, there was a political impetus to keep certain groups from voting, to keep black people from voting. So what Congress did is it passed a couple of statutes, and it sent the 15th Amendment to the states. And what it did was to try to, in certain circumstances, assert federal jurisdiction over something that is local. Now, to understand sort of how this worked, you have to understand how voting worked in the 19th century. In the 19th century, voting was public, meaning today, we go to a polling place, we go into a voting booth. Actually, I don't really go into a voting booth. I go to this little cubicle. Or I voted by absentee ballot last weekend, good, in Massachusetts, and I went to this sort of table. But it's what we call the secret ballot. In the 19th century, completely different. You go to the polls as a group. You bring your ballots with you, and you kind of vote as a group. Voting is really, really public. If you can't engage in this kind of public organization, you're much less likely to be able to vote. Lots of people can't read, right? Freed slaves. You need people to help you, people organize politically. So what most of our first generation, we might call them the first generation Voting Rights Act, the Enforcement Act and the Ku Klux Klan Act were directed at were voting regimes, let's say, that looked neutral. You know, by 1870 or so, African Americans could theoretically vote. But in practice, it was really hard for African Americans to vote because what looked neutral was in fact not so. Why was it not so? Because voting was public. And because it was public, there was rampant violence around voting. When you went to the polls, people did stuff. As a matter of fact, one of the things that was the impetus for the these first pieces of voting rights legislation was something called the New Orleans Massacre of 1866. It went like this. A group of African Americans and some whites were holding a political meeting in New Orleans, and the white supremacist mob murdered 35 of them. They were trying to organize in advance of the Louisiana Constitutional Convention, and they wanted that Constitutional Convention to enfranchise African Americans. So this is the kind of thing that began to happen in the 19th century. In the first era of black voting, if you left voting up to the local processes, things like this would happen. The local processes looked neutral, but in fact they were not, because what really happened on the ground was lots of violence. And the question was whether the federal government could assert jurisdiction over things that looked local, things that were traditionally the province of the states. And to kind of understand the moment we're at right now, we're kind of in the middle of a similar debate. There was an op-ed in the Wall Street Journal, for instance, written by a proponent of things like voter ID, saying that, well, you know, what's really going on is the federal government is taking things away from the states. This is the power grab by the federal courts. We know that voting is local, and it's inappropriate for the federal courts to interfere with local elections. Well, this was sort of exactly how people framed it in the first age of black voting. The question was, could Congress pass statutes that nationalized voting? Could Congress pass statutes that, I don't know, allowed you to prosecute, let's say, the people who engaged in the New Orleans Massacre of 1866? Or for our purposes, another, you know, the history of Reconstruction, you could actually do almost the entire history of Reconstruction with controversy after controversy that goes one way. Political organizations of African Americans are set upon violently by whites. And the question was whether or not the federal courts could assert jurisdiction over these kinds of things. And the most famous one was one that David Blight mentioned earlier when we were talking before the panel, something called the Colfax Massacre, 1873, Easter Sunday. Eric Foner calls it the bloodiest single act of carnage in all of Reconstruction. Easter Sunday, 1873, a group of armed whites murdered over 100 black men who gathered at the Grant Parish Courthouse in Louisiana in the aftermath of a disputed election. Now, the problem is that in order to prevent massacres like this, in order to prevent interference with black voting rights in our kind of first era of black voting, what the federal courts had to do is they had to assert jurisdiction over something that everybody understood was local. Murder is a state crime. Louisiana has functioning courts. Can a federal court take jurisdiction over something that looks like a state law murder? Or, to be more precise, does the Enforcement Act, right, our kind of first voting rights statute, right? We can think of it as a voting rights statute because, the reason Congress passed it was because of what happened when it came time to vote. Could you apply the Enforcement Act to something that looked like a state law crime? Ultimately, the United States Supreme Court says no. The Colfax Massacre is a state crime. It's under the jurisdiction of state governments. It's a local matter. Congress, the court rules, doesn't have the power to pass such a statute, or if the statute is passed, it doesn't have the power to apply such a statute to something that looks like a state law crime. The Colfax Massacre defendants go free. Reconstruction basically ends in Louisiana, and the Democratic Party takes over the state. So that's kind of like a quick and really dirty, like really dirty in a bad way, narrative of sort of the first era of black voting. There was this problem that everybody sort of grappled with, and the problem was this. Voting was formally free to African Americans, meaning there weren't state actors at the polls preventing African Americans from voting. But everybody knew in order to vote, you had to have some protection against rampant white violence. So could Congress pass a statute, enforce a statute that, Congress has the power to federalize voting, right? The Constitution gives it that power. The 15th Amendment certainly gives Congress the power to remedy voting deprivations based on race. But does Congress's power extend to things that look neutral, that, are kind of really part of the substance of voting, right? You can't vote in this period if you can't organize politically, and that look really local. Supreme Court says no, and essentially that is the beginning. It's not quite the end. The end doesn't come for another 20 years, but it's basically the beginning of the end of the first era of black voting rights. So I think, when Judge Keith, in that Sixth Circuit case about the Ohio voting restrictions, sort of appends sort of pictures of 36 African Americans who were killed in the context of voting, in the context of disputes over voting advocacy. I think when he invokes history, I think he's looking at things like that. And he's saying there's a really long history of this. A lot of people died. He says this in his opinion. A lot of people died to get voting rights for African Americans. A lot of people died to assert federal jurisdiction over something that looks local, voting. And even though, everybody understands that, we're not going back to a regime where people are killed by advocates for the other party for exercising their rights to vote. That history kind of lays in back of our present disputes and then informs them. And for Judge Keith, I think he thinks that we are not doing, we're doing a disservice to those who died in the service of voting, to accept things that look neutral, that are very local, but that everybody understands has a disproportionate effect on minority voters.
Thank you, Ken. Yeah, that number was approximately 150 blacks killed at the Colfax Massacre. I want to make sure we come back to this issue of federalism because it's absolutely at the heart of this problem, the local nature of voting. And to your point from Judge Keith, that we are living in different histories. I mean, it's so much a part of your book, Ari, that the way this gets debated, it is as if we're just living different histories. Anyway, but Beverly.
Sure. I was charged with doing sort of wrap up really big picture, so I will try to do my 200 years in 5 minutes. But I just thought I would throw out a few categories that might be useful for thinking about these questions, and then a few structural questions that I think are important in thinking about the current election and why so much of this matters so much in this current election. When we tend to talk about American democracy, we tend to say, you know, at its heart, it is about voting. You're an American citizen, you go and you vote. But of course, as you've gotten a sense from the panel, that is a much more complicated story, and it always has been a much more complicated story. So I wanted to offer sort of three categories that might be useful in thinking about how we make decisions and how we practice the process of who is actually able to vote in this country, who's able to exercise their citizenship. So one is the category, the sort of big picture category of whose citizenship rights are fully enfranchised. And of course, since from the founding of the country to the present, that has changed dramatically. We are a nation that started with a voting population that was restricted to property-owning white men. And that has expanded and then contracted in various ways over time. Mostly, we tend to think about our history as being a history of expansion from property-owning white men to all white men, the kind of full enfranchisement of the white franchise, as it was described, to the enfranchisement of African Americans, 60 years later, the enfranchisement of women, etc. But there are other ways in which these stories have been increasingly restricted over time. In the 19th century, it was certainly much easier to show up as a new immigrant and be able to cast a ballot, a new white immigrant, a new white male immigrant, and be able to cast a ballot in the United States than it is now. And I think at the moment, one of the big issues that actually hasn't been mentioned yet is the disenfranchisement of felons, of people who have been in the criminal justice system and who are either still within the criminal justice system or outside of it, but who have lost their voting rights. And that because we have such a large prison population and such an incarceration crisis in this country is now a really substantial proportion of the electorate. So we have a complicated story that is simply about who has the right to vote. And that is, as I said, largely an expansion story over time, but not wholly one. So that's sort of piece one. Piece two is what we've heard a lot about up here, which is, so of those people who have the right to vote, who is actually able then to exercise that right to vote? And that too has been an incredibly contested category and experience over time. So the deep, deep violence that black voters in particular were subject to in the 19th century is a critical piece of that story. Another famous moment in that from our fine state of North Carolina is the 1898 Wilmington Massacre, which is an almost literal coup within the city of Wilmington, North Carolina, in which an elected black Republican government with some white officials as well is literally overthrown through violence by white Democrats. And that becomes really fundamental to not only that city itself, but to the way in which the state of North Carolina is governed for a lot of the early part of the 20th century. So we have a story that is about violence. We have a story that becomes about poll taxes and literacy tests, which were, of course, primarily aimed at African Americans, but also had pretty dramatic consequences for poor white voters in the South. One of the things that you're seeing, and this kind of came up in terms of thinking about what it is that poll workers actually know, right? The more discretion that people at the local level are exhibiting, individual poll workers, the more these kinds of questions really come into contest. So poll taxes, literacy tests, and now we're seeing, of course, a whole new set of categories along these lines that are barriers to people actually being able to exercise their right to vote. So we have who has the right to vote, who is able to then, as an experience, exercise the right to vote, and we've got all of these new categories that are making that much, much more difficult in our own moment. And then we have a third category, which has also been part of the political language of our moment, which is the question of voter fraud. So once votes have been cast, how are they counted? how many of them are considered to be legitimate votes? How is the process of making sense of the election carried out? So it is also worth noting that voter fraud in this country has been an issue over time, and there's no point in suggesting that the United States has a pristine record, particularly in the 19th century, urban political machines in the 20th century, right? Voter fraud is a substantial part of the history of American democracy. However, at the moment, in part because political parties actually exercise somewhat less control over a lot of urban political machines than they once did. We don't happen to be statistically, as Ari said, we are not actually living in an age in which voter fraud is really, has been a huge part of our electoral process. There have been lots of studies of this, and while it does exist and has existed on quite grand scales at certain moments in American history, that is not the moment we're living in. So I would agree with all of the panelists up here that voter suppression and barriers to voting are the question of our age, of this election in many ways, and that these are not neutral questions. These have implications for parties. Certainly they have implications in terms of race and region as well. So just a few words about why that particularly matters at our moment in history. So I think one thing that has gone somewhat under-recognized is that we are living in, over the last 20 to 30 years, a really unique moment in the sense that we are living in an age of close presidential elections. And that has actually not always been the case in American history. A lot of elections in the 20th century were huge landslide elections on a scale that we have not seen. Most people sitting in here under the age of 50 have never experienced have never voted in a true presidential landslide election. So the last real landslide we have was 1984. And since then, we've tended to have very close elections. Now, there's a lot of back and forth about how close this election is likely to be, but it looks like once again, we are going to see really a close election that may be decided on the basis of fairly concentrated small numbers of voters. So the last piece that I want to have out there, so not only are we living in an age of close elections, but that these three moving parts, so who has the right to vote, who's able to exercise that right to vote, and then whose ballots get counted and how do they get counted, those in turn interact with a whole series of political institutions ranging from local governments to state governments to courts to other structures, to the ways in which our laws and our legal system are thinking about the right to vote. So we've got this incredible, what looks to be, the most simple thing in American democracy, which is to go to a voting booth and vote, is in fact one of the most complicated things that we engage in as a polity. And right now we have I think a variety of political forces and new legal structures that are really calling into question how we want our democracy to be run.
Wow, thank you, Bev. As usual, you took an impossible task and made it all make sense. And of course, there have been elections that have been swung by who gets to vote. Grant doesn't become president in 1868 without the black Southern vote, and et cetera, et cetera. Now, I have 2 or 3 questions I'm going to get the panel to discuss, and then we're going to open it to Q&A, and the microphones will be carried to you. You don't have to get up and stand at the mic. First, Ari, you begin, but others can weigh in on this. Help us understand just to bring it up to sort of current history, although I'm always more comfortable than in the 19th century, but tell us what happened after 2000, especially in the Bush administration, especially in the Civil Rights Division of the Justice Department, and then as a group, bring us up to the Shelby case. I mean, we've mentioned the Shelby case, which is so important in the North Carolina decision. And Section 5 of the Voting Rights Act, how did we get from the Cadillac system that came into North Carolina, particularly in the wake of the renewal of the Voting Rights Act, right, in 2006, to a Supreme Court that just sort of threw the baby out with the bathwater in 2013. So help us understand where this, because what happened in Bush, in Ari's book, I must tell you, is brilliant on this. It exposes, I mean, I lived through that, and I didn't quite, I mean, I remember complaining all the time, but I didn't really realize the depth of what went on in the Bush Justice Department.
Sure. Well, I just want to start by telling a quick story about the 2000 election in Florida, because I really do think that laid the groundwork for everything that's happening now. And I also think we're possibly at a position where we could have another election that's decided by 537 votes, the way the polls are currently looking. So there was obviously a lot of talk about the 2000 election in Florida and hanging chads and butterfly ballots and Katherine Harris and some elderly Jewish voters in Palm Beach mistakenly voting for Pat Buchanan. But there was a whole nother part of that election, which is that Florida did a massive voter purge in the run-up to the 2000 election in Florida. And Florida, as you mentioned, Bev, was one of only a few states where ex-felons were not able to vote. And this was a ban that dated back to Jim Crow, when African Americans could be labeled as felons simply for looking at a white woman, for example. Many states had repealed these bans, but Florida had not. And Florida claimed that all of these ex-felons were on the voting rolls and needed to be purged. The problem with the voter purge was twofold. First off, it was inaccurate. People were labeled as felons even if their last names, their middle names, their race, their sex data didn't match the voter registration rolls. The second problem was the purge was discriminatory. That African Americans, in particular in Florida, were 11% of the electorate, but 44% of those who were likely to be purged from the rolls. So what happened was, in the midst of all of these hanging chads and butterfly ballots, voters showed up, they were wrongly told they were felons, and they were prevented from voting on Election Day in Florida 2000. After that election, the NAACP sued the state of Florida, and the state admitted that 12,000 registered voters were wrongly labeled as felons and prevented from voting. And that number, 12,000 purged, was 22 times George W. Bush's margin of victory. And so while coming out of Florida 2000, lots of people said this can never happen again, we have to fix our voting system, the people that won or were handed that election had a very different conclusion, which was that small or not so small manipulations to the country's voting process could make a very big difference in close elections. And that talking about voter fraud, whether or not the fraud actually existed, was the way to then build public support for these new kind of restrictions. And so what happened is, not only is George W. Bush then elected largely because of this, but a whole new generation of voting rights critics are empowered in the Bush administration. And they take over the Justice Department, and instead of the Justice Department filing suits under the Voting Rights Act to stop discrimination, suddenly the Justice Department is taking part in this discrimination. And they're very critical of things like the Voting Rights Act, and of course, George W. Bush appoints people to the Supreme Court like John Roberts, who ever since he was a young lawyer in the Reagan Justice Department, wanted to gut the Voting Rights Act. So they empowered people who had decades of a past that led to wanting to undercut the Voting Rights Act. And so I think that Florida 2000 really laid the groundwork for what happened, because in 2008, it wasn't just that the first black president was elected, it was that there were 5 million new voters that cast a ballot. And of those 5 million new voters in 2008, 2 million were African American, 2 million were Latino, and 600,000 were Asian American. And they voted 75% for President Obama. And so if you're the opposition party and the fastest growing demographics in the country have just voted overwhelmingly against you, you really only have two options. You can either change your policies, try to reach out to people that don't agree with you, or if you're unwilling or unable to do that, you reach back in American history, right? And you make it harder for those people that disagree with you to be able to cast a ballot, and you try to gut things like the Voting Rights Act that would stop that discrimination from occurring.
Yeah, they converted the Civil Rights Division of the Justice Department into effectively voter suppression. Anyway, irony makes the world go around. But then the Shelby case, who wants to pick it? Ken, you want to, I mean, this is a huge turning point when the court, led by Roberts, aggressively by Roberts, gets rid of Section 5. And you might briefly explain what Section 5 does for anyone who doesn't know.
Okay, so the Voting Rights Act of 1965 it federalizes certain aspects of voting. So it does a bunch of different things. But Section 2 is the part of the statute that's most used now. Things that have a disproportionate effect on African Americans can be, things that have a disproportionate effect based on race can be challenged under Section 2 of the Act. And in fact, there's been a long struggle over what we might call the effects test. There was a Supreme Court case, I think in 1980, that construed the act as only applying to intentional discrimination, and then Congress, Republicans and Democrats, actually amended this statute and made it clear that it applies to changes in voting procedures that have a disproportionate effect based on race. But the most potent part of the statute was Section 5, which required certain jurisdictions to get pre-clearance before they changed their voting procedures. Pre-clearance either from a federal judge or from the Department of Justice. So there's a whole section of the Civil Rights Division, this whole part of the Civil Rights Division of the Justice Department which focused on pre-clearance, right? So if you change your voting procedures and those changes might affect minority voters, you had to get pre-clearance. Now, Section 4B of the statute, which is the one that was invalidated by the U.S. Supreme Court, defined which jurisdictions were covered by pre-clearance. So you didn't have to get pre-clearance all over the United States, only in certain jurisdictions. And those jurisdictions were disproportionately concentrated in the South for obvious reasons. And the statute was amended several times. The coverage formula for B doesn't change that much, still disproportionately directed at the South. And the last amendment, which the Supreme Court overturned in the Shelby County case, was in fact a bipartisan amendment, right? So Republicans and Democrats largely voted for this thing. Southern Republicans voted for it. So under the statute as it existed before the Shelby County case, there's kind of two really relevant provisions for us. If you do certain things that have a disproportionate effect on voters based on race, you can challenge those. But in certain jurisdictions, every change in the voting procedures has to get pre-clearance from the Department of Justice. So, how to tell the story? I mean, one part of the story is kind of exactly what Ari said. Chief Justice Roberts has been hostile to the statute ever since has been suspicious, put it that way, of the statute ever since he was in the Department of Justice, the Reagan Department of Justice. But there's a kind of larger narrative. I mean, if you read the Shelby County decision, Roberts has this famous line where he says, things have changed in the South. And so for people like Roberts, the baseline is that the South is very different today than it was when they first put together the list of jurisdictions covered by Section 4B. It's kind of singling out a particular region and treating it differently, a particular set of jurisdictions, and treating them differently than it treats the rest of the country. And so there's some problem with that. Now, we might say, some problem like that doesn't translate into unconstitutional. So the majority in Shelby County essentially invents a new constitutional framework, a thing that doesn't exist, this principle they invoke called equal sovereignty. So the court says it impinges upon the sovereignty of the particular states that are singled out in Section 4B to apply a set of voting restrictions to them that are not applied to, let's say, Massachusetts. And therefore, Section 4B is unconstitutional. So Section 5 still exists, right? There's still the pre-clearance provision is still there. It's just the set of jurisdictions that were defined as being subject to pre-clearance has been invalidated by the U.S. Supreme Court. And as Ari said, there was an impetus to make it harder to vote before that decision, and kind of within a month of that decision, the impetus gets stronger, and we are on the road to where we are right now.
And Bev, could you comment at least briefly? I mean, you teach about conservatism and liberalism, a seminar on it, and that part of what was going on in these years, the Bush years up to Shelby, is an ideology and a language used by the right about colorblind conservatism, ballot integrity. It's as if they invented a new modern language for, and what the phrase you just used, Ken, for, in effect, states' rights. That's what it is, equal sovereignty. But there was a new language from the right, and they succeeded in some ways politically with that language, didn't they? I mean, with millions of voters.
Mm-hmm. Right. I think that that's fair to say that there was a new, ostensibly race-blind language that emerged that nonetheless had quite clear racial implications. One of the other things that has happened during this time period and over the last 40 or 50 years is that we also have much more ideologically distinct parties than we once had. So, if you look back to the middle of the 20th century, our party system really looked quite different. I mean, so in part, before the mid-60s, you didn't have large numbers of black voters, but your white South was in the Democratic Party. You had a lot more overlap between the two parties, and the two parties have become much more ideologically distinct, and therefore you're getting a lot more separation around these kinds of questions as well.
Well, and I'd like to say that the practical effect in southern states in previously covered jurisdictions is that, so these tiny changes that Bev and are referenced in Ari's book, and like the purge, stuff like that, those tiny administrative changes or small administrative changes then became very difficult to monitor. So under pre-clearance, moving a polling place, for example, would be reported to DOJ and available on a website that you could go check, and you could see which counties in North Carolina have moved polling places and from where to where, and you could look at the numbers, et cetera. Now without pre-clearance in place, that means that because voting is a local institution, you've got to have folks at every local Board of Elections meeting to try to figure out what's going on. So in North Carolina, we've got 100 counties. Democracy North Carolina happens to have, we come out of the civil rights movement, so we've got this organizing orientation. We happen to have folks who can cover about half of those counties, and we've got Open Records Act, so we can have some sense of what's going on. It takes tremendous effort. The benefit of other states like Georgia, they don't have the kind of social justice infrastructure to allow them to monitor every single county, and so it makes it very difficult for people who are on the ground advocating for voting rights to keep an eye on what's going on. And this major tool is gone, right? It's no longer on the state or the local jurisdiction to prove that the change that they will make is not discriminatory. It's now up to the voters and voting advocates to show that this will have a discriminatory effect. And so one other dynamic of the Fourth Circuit decision in North Carolina and some of the other recent wins for voting advocates has been that we've seen this animation of Section 2, which had sort of been dormant. It had been a dormant section of the Voting Rights Act, whereas the Section 5 had been the active section. And now we've seen a lot more action around Section 2. But I'll say that it's sort of like the Shelby case just really lifted the top off, or let the genie out of the bottle, right? The genie of voter suppression and the ability for local jurisdictions to do what they wanted with voting laws and the out. And so those of us who are voting rights advocates are scrambling, especially in states that have less. North Carolina happens to have a pretty great voting rights infrastructure. In other states, folks are scrambling to figure out how to address the various issues that are being raised and figure out what are voting rolls being purged, are polling places being moved, et cetera.
Well, it's interesting. I'm glad you said that, because isn't one of the aims of voter suppression to simply sow confusion? Confusion suppresses vote. I mean,
It's certainly
it just does.
very effective.
You don't know where to go, and you don't know if... Yeah. And
Right.
was it Texas that took all the 48 hours after the Shelby decision to announce a voter ID law? It's like
I think they doubled down.
or they already had one?
Yeah.
Or yeah. So they didn't wait very long. I have a lot of other questions, but I'm going to shut up, and we're going to open this to Q&A. The microphones will be handled by Melissa over here and Michelle over here. So who's up? Yes, Jim. Or no, it's the man in front of me. Forgive me. Sorry. I see a hand through the light. Yes, sir.
Yeah, I'll just go right to my question. I wanted anyone on the panel to address, I know you spoke earlier about the Force Acts and the impact that had, with Ulysses S. Grant. I wanted to know your thoughts on what about President Obama's reaction to present-day domestic terrorists that have stated that they're going to be at different voting places. Politico and other groups have reported on this, that the leader of their party has said that they're going to come out. So it's basically we're back to square one again with mobs, possibly being out trying to intimidate voters. And when you have a president who admonishes the African American community to continue his legacy, what do you think he should be doing outside of giving a speech to protect voters of color that are going out to these polls and can possibly be in situations where they're threatened and intimidated?
I mean, I can say that I know the Department of Justice is trying to figure out, led by Loretta Lynch, who's a native North Carolinian, is trying to figure out how to get their staff out into the field in some of the states that have been targeted by, have been specifically named by notably Roger Stone, who's, stopthesteal.org. I think we've gotten the most information about what his plans are. The rest of it is a lot of rhetoric, and it's terrifying rhetoric, it's alarming rhetoric, it has no place in our democracy. But I will say that I know that there is an effort, even if it's not, it doesn't look exactly like President Obama sending FBI agents out. It is DOJ is trying to do something about it.
Can I add on that? Because, so one of the things that the gutting of the Voting Rights Act did was that the Justice Department can't send federal observers anymore to places with a long history of discrimination unless they have a specific court order. What that means in practice is that since 1965, 32,000 federal observers have been sent to monitor voting, meaning they can be inside the polling places, watching the votes cast in places in Alabama, Mississippi, Georgia, et cetera, that have had a very long history of voter suppression. Now, so in 2012, they had 780 federal observers and Justice Department personnel in 23 different states. Now they're only going to have federal observers in 7 counties in 4 states where they have specific court orders. They're going to send what they're calling election monitors to places like North Carolina, but those people can only go in and monitor the voting if they're invited in by the local Board of Elections. And some of these Board of Elections in places like Texas and North Carolina are not going to be that hospitable to the Loretta Lynch Justice Department coming in there. So I'm concerned on the one hand, we have, as you mentioned, this unbelievably dramatic escalation of voter intimidation. Whether or not it comes to pass, the rhetoric has been insane and totally unlike any other presidential election we've had. It is very much more reminiscent of the things that we saw in the 19th century. On the other hand, we have the fact that the federal government has fewer tools than they've ever had before since 1965 to try to stop it. So that's going to mean that groups like Democracy North Carolina and the Election Protection Coalition, which is 866 Our Vote, and I would urge everyone to know about this site on Election Day, are really going to have to pick up the slack here. And I just want to say Democracy North Carolina has been doing such amazing work. Stella didn't tell me to say this, but if you're looking for a group to support where you know that your money is going to have an instant impact, I would seriously say support the work that they're doing. It's been so valuable in both helping people vote and also in giving journalists like me the information to be able to report on this.
You want to give out your website?
Sure, democracy-nc.org. But I'll say that, the Election Protection Coalition, 866 Our Vote, it is a tool. It's not the government. But it's a coalition of nonprofits, legal advocacy organizations, and other groups like ours on the ground. And if you hear of voter intimidation, if you experience a problem, we want to hear about it. You know, it's best if we hear directly from the voter or the person that it happened to. It's hard when we get repeated rumors, you know, because we have to prove it. We have to prove what we're hearing from voters to sometimes hostile local election officials. But I mean, we're gonna, like I said, we're gonna try to, we will have 1,000 at least volunteers. There's so much interest now toward the end, it's very tough to manage. But we'll have 1,000 monitors on the ground, about 200 lawyers on the ground. Other folks like DOJ will be present. And then, and election protection has, they also will have field monitors in other states, for example, Texas, which is another area where you've got a lot of threats. So people are pushing back, people are trying to protect the vote, and then I'll say, you know, North Carolina has not, we haven't seen this level of rhetoric, and we haven't seen it from a presidential candidate, but there have been a lot of concerns about voter challenges over the last 2 cycles, and they haven't manifested, you know, because fundamentally it's an organizing question.
Yeah.
It's one thing to say you're going to do this. It's another thing to organize and make it happen. I'm not saying it doesn't depress the vote. I'm not saying it doesn't scare people away. But I am saying that we'll have to see how much it actually manifests.
Who's next? Yes, please. Yeah, go ahead. Use the mic.
The other day, Davo Adigbile came and spoke to us, and he talked about the importance as well as the limitations of Section 2 litigation. And
Who was this? Who came?
He's the former director of the NAACP litigation.
Oh, okay.
And as well as kind of obstacles in the way of bail-in and of course the difficulties of getting Congress to enact a new coverage formula and restore the prophylactic protection. So I was wondering, what is your assessment of those different avenues for change, recognizing of course that the membership of the courts and Congress depends on the election, and if you were, say, a powerful member of Congress, how would you devise a new indicia of voting problems in a way that would be persuasive to the Supreme Court, but also recognize the long-term history that was the rationale for the original Voting Rights Act and its reauthorizations.
Positive, forward-looking question. Thank you. Ken, you're the member of Congress.
All right.
That's a good idea.
Yeah, I mean, there have been. Yeah. There have been new versions of the voting of Section 4B that have been propounded. So what the Supreme Court did is, they just said that the coverage formula of 4B was outmoded. So Congress has the power, although, I should also mention that, the last time Congress amended the Voting Rights Act, they did hold hearings. They did mobilize evidence, and they did demonstrate exactly why they were writing the statute the way they did. And the Supreme Court disbelieved them. It was Democrats and Republicans who voted for this thing. But Congress has the power to hold new hearings, to assemble evidence, and to decide how it's going to write another Section 4B and to write it. The question is whether you could get Congress to pass it and a president to sign it. President Trump would never sign it. The Republican House, as it's presently constituted, will not pass it. You would either need a change in the sentiments that Ari has identified, or you would need the House and the Senate to change hands before you can do that.
And another justice on the Supreme Court.
And you need another justice of the Supreme Court to make sure it's not going to be invalidated.
I just also wanted to mention 2 other sort of structural, in the presidential election in particular, 2 other sort of structural pieces, one of which I think is at the heart of this whole conversation that we will be unable to change, and one of which has had dramatic impacts this year that actually may be subject to some change. And they're both related to voting rights. They're not exactly that issue. So the first is the Electoral College, right? So one of the things that is so dramatic, and one of the pieces that keeps producing these kind of close elections and all of this deep anxiety about 537 voters in Florida, right, is the fact that we run our presidential elections through an electoral college system. So that is a piece that is fundamental to this, that if we were to get rid of it, would transform the process of voting, people's willingness to vote, people's enthusiasm about voting, the process of voting. But that is the piece that I think
Everybody campaign in California.
Right, needs to be front and center and is deeply unlikely to change because it is a fundamental structural piece of our electoral system. The other piece that I think may actually be up for some play is the primary system. So I think we have an unprecedented situation right now in which one of our major parties has at the top of its ticket a man who the party establishment does not want to be at the top of the ticket, right? And it's worth noting that Donald Trump became the Republican presidential candidate with about 35% of the primary vote. So even among Republican primary voters, he was not the majority candidate simply because there were so many candidates. Which is to say that the primary system, I think, is a piece that may be looking at some reform. So we've really only had binding primaries in this way, that the popular vote in primaries is the way that parties choose their presidential candidates. That's actually pretty new in historical terms. That comes out of reforms from the 70s, really. And so it's become very normalized to us, but there are a variety of other ways that one could think about that. And both because there have been some deadlocks within the Democratic Party, in which the issues are slightly different, and because I think the Republican Party itself is feeling in crisis over the current situation, we actually may see coming out of this election a set of the parties run their own primaries, basically, and set up their own structures, more or less. So that we actually may see come out of this. Now, what those changes will look like, we don't know, but there is, every 40 or 50 years or so, the parties do tend to kind of rethink some of these questions.
But I think the answer is we have to wait and see. I think North Carolina may be on the cusp of bail-in, and I think, following the Fourth Circuit decision, we'll have to see what happens with the Supreme Court. But I think that would be the first bail-in since Shelby. So it's all in play.
So can I just explain that quickly? So,
Bail-in.
Under the Voting Rights Act, if a state is found to have intentionally discriminated against people of color, they can be what Isela was saying, bailed in, and have to once again approve their voting changes with the federal government if a judge orders that. Now, North Carolina was found to have intentionally discriminated by the Fourth Circuit, but the Fourth Circuit did not decide to bail them in. Texas, again, was also found to have intentionally discriminated in their voter ID law against blacks and Latinos. That intentional discrimination finding was overturned by the Fifth Circuit Court of Appeals and kicked back to the lower courts for another trial. So there's actually, after the election, there's going to be another trial in Texas to find out if Texas intentionally discriminated against people of color and once again have to approve their voting changes with the federal government. It's going to be a limited remedy, but still, Texas has had more voting rights violations than any other state. So if they had to approve their voting changes, that could be interesting. It would set up a massive fight between Texas and the federal government yet again. But one of the proposed pieces of legislation, the Voting Rights Advancement Act, which is one of the bills that would restore the Voting Rights Act, would make it a lot easier to bail in states if they discriminate against people.
Let's take one more. You? Use the mic.
Thank you. You've all told a story of legal suppression, if one might put it like that, of voting rights, leaving aside the questions of intimidation, but actually a sort of process of suppressing of voting rights, which does rather beg the question that David asked to start with, which is why the media hasn't focused on it to anything like the extent that they might have
So
done.
glad you asked that, because I was gonna.
But I mean, just
please.
reading about American politics from England, the New York Review of Books has written a lot about it, but almost nobody else seems to have done so. Is that because All right, you did. Okay, but it hasn't been a big issue, and it still doesn't seem to be a big issue even now in the media presentation. Is that because people assume that if Donald Trump was the Republican candidate, it wouldn't matter so much? Or is it just because it's a difficult story to tell, and therefore it's hard to get people to understand it?
Yeah.
That's the sort of first 3/4 of the question, and the final quarter is it actually going to make a difference in 5 days' time?
Yeah. So, well, as a member of the media who's been one of the only people to cover this, I'll take a stab at it. You're absolutely right that it has not gotten the attention it deserved. We had 25 presidential debates in the primaries and then in the presidential race, and there wasn't a single question asked about voting
Not
rights.
once.
The closest we came was asking Donald Trump if he'll respect the election returns. But that's not a question about the gutting of the Voting Rights Act or new voting restrictions in place. So clearly the debate moderators weren't necessarily reading everything I wrote. Why are they not covering it? I have a few different theories as to why. The first is that this is about race, and race makes people uncomfortable. And unless there's a police shooting or something really dramatic, we just like to not talk about it. That's the first thing. The second thing is that this is about partisanship. One party is doing this to hurt the other party. There's lots of racial overtones, but I think this is still primarily driven by partisanship in this day and age. And so what we see is when it is written about, the headline says, Republicans allege voter fraud, Democrats allege voter suppression. Well, which one is it? Is it voter fraud or is it voter suppression? And I think there's this he said, she said mentality on so many issues that carries over to this. And people are unwilling to say, quite honestly, that voter fraud is a very small problem, but voter suppression is a much bigger one. When Trump started talking about rigged elections, for example, you heard a lot of people in the media debunk what he was saying. Oh, it's so ridiculous. But then they kind of scoffed at the idea that anyone would be turned away from the polls, which is very, very real. As Democracy North Carolina showed, thousands of people were blocked from voting in 2014 by eliminating things like out-of-precinct voting and same-day registration. At the same time, North Carolina only presented 2 cases of voter impersonation in court out of a decade. So there was many, many, many more people turned away than cases of fraud. So I think that's another reason is they're afraid of how to handle the partisan dimension. And then the third thing I think is that the media lives in its own kind of bubble. It's doesn't represent the demographics of the country, and it doesn't represent the socioeconomics of the country. So most reporters are going to have a photo ID. They're not going to think it's a big deal to have a voter ID law.
They have health insurance too.
Yeah, so they're not going to dig, and so people say, what's the big deal with the voter ID law? And for 85 to 90% of the public, including 99.9% of journalists, there's not a problem. You have to find the 10% of the public that don't have this, and that requires you to do digging. And it's easy to put a bunch of talking heads on TV and debate the latest poll numbers for 15 minutes. It's a lot harder to go out in the field in North Carolina or Texas or Wisconsin and find these people. And so sometimes the New York Times parachutes in, sometimes the Washington Post parachutes in, but I don't think that it's been covered for all of these reasons that I mentioned in the kind of sustained way it needs to as a full-time beat like I've covered it.
Your 3-part answer is terrific. Let me take the knife you just put in the Republican Party and maybe turn it one more time. Because there are places in Ari's book, for example, you're covering the actual debates in the North Carolina legislature, or you're in the Texas legislature when they're debating this passage, and a Democrat will get up face-to-face with a Republican and look him in the eye and say, why are you preventing black people from voting? And usually there's no answer. They look at their shoes, or they say it's about voter integrity. You would think that journalistically, that's a dramatic, thing to cover. This is somebody being utterly exposed for denying people the right to vote, and yet maybe there's just something. I think you're right about 10%. 90% of us have these things and wonder why it's a big deal, and yet the right to vote is so basic. You'd think that more than 1 or 2 journalists would just take this
Well,
issue.
I mean,
And they have. There was a piece in the New York Times Magazine that
Yeah.
used a lot of your book.
Well, I mean, it's not just voting rights. I mean, the climate is rapidly melting, and there wasn't a single question about climate change either. So this is not only a voting rights issue. Can you talk a little bit about this, though, the impact? So we've already seen the impact of, for example, closing polling places on North Carolina on turnout.
Sure, I mean, yes, and I guess to the larger point, I think it is a boring story. It's a question about election administration in a lot of ways at this point, and we don't have these bloody massacres of the 19th century, and it is also a question of the larger environment of racism in North Carolina and rural poverty and all over the country, and it's very much about race. And I think while it is about party, also it's certainly I don't think that every black voter feels like they're fairly represented by either political party. So anyway, I think it's a real challenge to cover, and Ari has been amazing. And so what we've seen, the story I'm going to tell you may also be very boring, because it's not a story about Mr. and from Wisconsin.
Oh, Eddie Lee Holloway Jr.
It's not a story about Mr. Holloway Jr. It is a story of official county action. So essentially, let me see if I can boil it down here. When the Fourth Circuit acted and restored the first week of early voting, that Sunday had historically been used by black churches in North Carolina for their Souls to the Polls efforts. So when the Fourth Circuit restored that week, they restored it to the statutory state it had been in 2012, which was no minimum requirement on number of hours, or the only minimum requirement on hours and sites was one site in any county, normal business hours, Monday through Friday, 9 to 5, okay? So the Fourth Circuit decision came down, ironically, after 2 months of advocacy around boards of elections early voting plans. So our Democracy North Carolina advocates out at these board of elections meetings saying, we want these sites, we want these hours, doing all this advocacy and organizing. All the plans were in. We were feeling great. We got a lot of Sundays. We got a lot of campuses. It was really good. And then we had to start all over, right? But counties had the option of only opening one site for that first week. And a shocking number of the urban counties took it. So Guilford County, which is where Greensboro is located, also the home of the sit-ins, only opened one polling site for the first week of early voting. They opened 22 for the last 10 days. So we're not talking about 1 versus 4. We're talking about 1 versus 22. And people in Guilford County went out to vote. It was the first week of early voting. People are not paying attention to what's happening at their Board of Elections meetings, this tiny appointed body of 3 people. We did a lot of organizing and advocacy.
Some of you were probably on one, and
there were hundreds of
you're
people.
lonely, right?
Hundreds of people turned out, actually, to the meeting where that early voting plan was voted on. They sang, they protested because no public comment was allowed. So it was an extraordinarily dramatic moment, really covered very beautifully by the media in a shocking turn of events, because again, these are pretty boring administrative processes. But still, a lot of Greensboro residents didn't realize that they only had one site open. We got a very angry call at the election protection hotline from a voter who said, this is voter suppression, and she was right. And turnout is dramatically down in these counties that only had that one site open. In addition, many of the additional 22 or 25 sites that would open in the last 10 days have been moved out of African American communities. They're now in, for example, the suburbs of Winston-Salem, as opposed to the heart of Winston-Salem. But so that is a story that affects black voters, affects all voters. It's a story about the structures of our election administration that appear neutral, race neutral on their face, that are in compliance with the law, but are having this negative effect on black turnout and on voting in North Carolina. Boring.
Let me say one thing. Last thing. I can think of 2 scenarios in which some of the things we've been talking about will get greater media attention. One is scary. The other one's more hopeful. The scary one is if what happens 5 days from now is a repeat of 2000, where suddenly we looked at, certain aspects of voting, although not other aspects of voting, which is what Ari's point. And suddenly we became aware of all this stuff that nobody ever thought about. And, and if what happens 5 days from now is divided in a certain way, then all this stuff will suddenly matter immensely. That's the scary one. The more hopeful one is that it's clear that this is going to the U.S. Supreme Court. I think two issues. One is the effects test under Section 2, right? The way the statute's written right now is that it's a violation of the statute if to have an effect on minority voters. You don't have to intend it. I know Chief Justice Roberts has been hostile to effects tests of all kinds, but the statute was deliberately rewritten in 1982 to add that test. So that's the test in the statute. If Roberts is going to invalidate it, he's got to say it's unconstitutional. So that's one's going. The second issue that might go is that in North Carolina, as a bunch of people mentioned, the Fourth Circuit found that there was they suggested that there was intentional discrimination. It turned out they put evidence was put into the record that, before the North Carolina legislature decided, which voting methods to cut back on, they asked for information about which voting methods were most heavily used by African Americans. So it's kind of, pretty open that this is intentional. The Fourth Circuit sort of said it. That one's going back to the trial court. The Fifth Circuit case from Texas going back to the trial court. We might have findings of intentional discrimination. And that issue's headed to the U.S. Supreme Court as well. And the resolution of both of those is going to depend on, who's the next justice. So the more hopeful story is that, it's going to go to one of these issues, or both, is certainly going to the U.S. Supreme Court within the next few years. It's going to get decided. It's going to throw more light on the issue, and maybe we'll get more articles written about it.
I guess,
Well,
I'm
go ahead.
sorry, one other thing I'd just like to say is that something that draws media attention to the issue is organizing. So that's how we got people to attend the local Board of Elections, or write about a Board of Elections advocacy. We organized. And so I of course, we love our legal teams, and we're happy for positive legal decisions, and we're grateful when good laws can be passed, and we're trying to affect administrative change, and we're organizing. So I think that's for all of us, all over the country, to try to organize around voting issues and reinvigorate our democracy, and think of it, these aren't just, we're not waiting on the media to tell the story. We're not waiting for a historian to put it into context for us 30 years later. We're not waiting, no offense, you guys, I love history.
15 or 20.
We're not waiting on the courts to rule, right? And the Supreme Court maybe the Senate to confirm a justice, I don't know. But we're taking it into our own hands, because this is our democracy and our government and our voting system. We don't have to wait.
I just wanted to, I was going to say this anyway, but maybe it is just the fault of us historians, since most Americans still don't understand Reconstruction. But it's not because we haven't tried. You'll remember we did a panel last April on the legacies of Reconstruction. That has been converted into a documentary film. It's a 20-minute short. It's on YouTube, Yale YouTube, called The Legacies of the 14th Amendment. We have filmed this. We're going to do the same. It'll be well edited, boiled down to a short film after the election, so it'll be in a whole different context. But I think you brought this up. We really are living different histories. Perhaps we always are. People just choose the memory and the narrative they want to live in. Because a lot of these people who were in that Bush Justice Department, I mean, they're real believers. They just don't believe certain groups of people, one, either should vote at all or should have any help in voting. And Roberts, I mean, he's just a believer that any kind of, I don't know, whatever you want to call it, help from the federal government is just against the Constitution in his view. We really do live different histories. So at the end of the day, whether it takes 20 or 30 years, it does get fought out there too, because we all walk to the polls with just different histories in our heads. Anyway, thank the panel with me if you would. It's been a great panel, I think.